Welcome, everybody. Today is May 25th, 2023, and today we're talking about parenting coordination. And I want to admit that I don't have that much experience with parenting coordination, doing appeals only, and it doesn't really come up in our cases very often. So I'm so pleased today to have joining us Traci Rink, who was at the Friend of Court for Oakland County referee for I think 18 or 16 years, 18 years. And now she's in private practice doing mediation. And I think she's going to start doing guardian ad litem and maybe some parental coordination work as well. And we also have Ben Burgess. He is a limited licensed psychologist at Fountain Hill in Grand Rapids. And I think we're so excited to have you, Ben, because you can really, you've been a parental coordinator, parenting coordinator, and you can really tell us what it's like boots on the ground, but also because now Zoom is such an accessible thing for us. I think that it's possible for you to do parenting coordination even if the family is not right in the Grand Rapids area, because there's not as many in-person, it's not as necessary to have in-person visits. So we're really excited to have you here, and hopefully some people that need help of parenting coordinators can turn to you for some help. And I just know the statute has not been around that long. I think it's from, we're going to talk about it in a minute, but the statute was enacted in 2015. So, we don't have that much experience in the big scheme of things. And I'm going to type in the chat the statutory reference so everybody has it. So welcome, Traci and Ben. We're going to start at the beginning, I guess. Here, I'm just typing. I can't do two things at once. Start at the beginning with MCL 722.27C. This statute is 2.5 pages long, and it has everything in it. It's really, that it probably needs improvements, but it really has a lot of details. And so if you have a case that you think might benefit from parenting coordination, first, I would recommend, we're going to talk about a lot of the details in the statute today, but just sit down and read it because it's not that long, and you'll have a much better understanding. So let's start at the beginning. If Traci or Ben, I think you might have an introductory comment you wanted to share with us, and we'll start asking you questions.
Well, yeah, I think it's important to start at the beginning, like you said, with the statute and with the order that directs the parent coordination. As a reminder, that now has to be a stipulated order, and you need both parties on board, and you can't have a judge order them. And that changed a number of years ago. But it clearly outlining the order, making sure that everyone is on the same page is really starting at the beginning.
Right. And I think there's a lot of things that the order should include. I don't know if we'll be able to share any sample orders with the attendees after the fact, but I think that might be helpful and getting everything into the order, because again, it has to be stipulated to. So one of the things, I think there's several features of things that, let's talk about what you should have in your order, just as a general matter. There has to be a deadline, like an end of the term of service. So you're not coming on as a parenting coordinator or a parent agreeing to use a parenting coordinator. They're not committing to each other for life, right? What's the typical term of service that it's included as the end date in the parenting coordinator order?
1 year is common. I don't, off the top of my head, I don't recall doing less than that. I have done 1 year, 2 years. One family committed until their child was 18. They weren't that far away. But it's hard to accomplish anything in less than a year.
And if there is an agreement for 1 year, can the parties agree to renew it?
Absolutely.
Okay. So I think I want to dive in, like there's a lot of topics that could go into the order, but I think I want to dive into really what is the role of the parenting coordinator. and what can the parenting coordinator do? How can the parenting coordinator help? And Traci, I know, you serving as a referee for as many years as you did, you kind of have a sense of like where the court appreciates the role of the parenting coordinator. We can talk about that as well. But let's start off by talking about the statute and what is the parenting coordinator allowed to weigh in on?
It looks like the statute gives a wide variety of topics. You can't change essentially the established custodial environment or change any parenting time, the extent that it makes an impact really in what that is. But the parents can agree to a wide variety of things that the parent coordinator can work on. Extracurriculars being obvious, school issues, medical issues, things like that. So I think it's important when parents decide to do this. And as we've said here, it can't be just judge ordered. It has to be parents consenting. But when the parents consent, I think they should really be able to have input into what things they're putting into that, because the parent coordinator statute gives a lot of discretion as far as what topics are in there. And there may be some topics they don't want in there. But I think the main purpose, looking at it from the role of the friend of the court, not only the referee, but from our family counselors in Oakland County, which we were fortunate enough to have, not every county has family counselors. The idea is that they can be on the ground, boots on the ground, settling issues that come up for Memorial Day weekend. Here we are on the brink of Memorial Day weekend. And maybe the order is written so this dad's holiday, but mom's weekend in rotation. And they're like, why did we do it that way? Why didn't we make it whatever? So a parent coordinator can maybe make that decision. By the time it gets to the referee or the judge or the family counselor, it's like on Tuesday afterwards saying, both parties screaming about what happened or didn't happen. And a parent coordinator can maybe, the best example is that a parent coordinator can help resolve those issues as they arise if both parties have a buy-in, participated.
So I wanted to point out there's two parts of the statute that talk about what you can't do. And you mentioned one of them, you can't make alterations to the parenting time schedule if it changes the total number of overnights in a given month. So you can change a Tuesday to a Wednesday, you can switch things around to help the parents, have a more peaceful life, but you can't say increase one parent's time overnights in a month or reduce them. And the other thing a parenting coordinator cannot do is recommend that relief that is less protective than any other order. So like if there is an order in place, how about we said, for example, there's an order in place about the people that can be in one parent's home during parenting time, and it says you cannot have X person there. Well, you can't change that court order, right? So I wanted to ask Ben, because you've sat as a parenting coordinator, what types of issues are you most commonly asked to weigh in on as a parenting coordinator?
You nailed it a moment ago when you talked about Memorial Day. It's stuff like that. It's daily issues related to parenting time. Whose holiday is it? What time are they making the exchanges? That's a common issue. One of the first things I often deal with in parent coordination cases is a therapist for the child or children. You may have a therapist who is untrained in court-related work and has aligned with one parent inappropriately. So finding a neutral therapist is often critical and an early issue. Medical care sometimes you're making decisions so small as to which parent can be present at a particular sporting event, because to have them both there would result in
Conflict
in public.
Well, Ben, I want to pause you for a second, because you talk about these small issues, but I've seen trial court motions, I've seen appeals that have addressed those issues. And I think the fact that if you help resolve them at the parenting coordination level, it means Traci, tell me if you agree with me, that means their parents don't have to file a motion and then, potentially have even an appeal about, a bunch of issues that includes some of these, what we would consider minor issues, but maybe aren't so minor to the parents.
Well, I think that's important because obviously as a referee or judge, you're correcting things weeks later, and then it becomes something that does make a record, which results in an appeal. It gets to you. But I'm thinking of things like in going back to that can't make it less restrictive. I would think one of the issues that might arise often is like, let's say you have an order that says the parents are going to meet at the police station because there's been conflict or domestic violence or something, and they're approaching you saying, well, we're going to be at these fireworks or this place and we want to exchange at the McDonald's and wherever instead of the police station. I'm wondering whether that presents a problem because there's a police station input for a reason, and less restrictive might mean somebody's home or like a park or something like that. And I don't know to the input behind the statute and putting something in there, but less restrictive or less protective. I think less protective is the word. Then you're talking about making an alteration that could be problematic because it violates what the judge ordered in that situation. But the idea is that you want to resolve the things that the court can't possibly resolve because it's in the moment, which also means that people who act as parent coordinators have to give up their weekends and holidays because that's when these issues arise to essentially be available for these people in real time when things happen, which can be, I'm sure, very stressful.
Well, and to address that point, on the front end of the process, you may be doing that. You may be dealing with things in real time. You know that you're being successful when you're dealing with things upstream, so that you're ahead of the game and you're on top of the current issues and you're addressing what's happening in the near future. And you avoid those problems.
I would think you'd have to really have the buy-in and trust of the parents to be able to look upstream. That has to be so personality driven as far as parents' willingness to say, and the parenting coordinator being proactive and saying, hey, I see this coming up. Let's work on this before it becomes a problem and a drama for the kids. Because ultimately, we're all here to protect the kids. So any of these things, especially, and that's amazing to look upstream at what problems might be happening, like it's graduation season, you know what I mean? And there's parties and things like that. I mean, there's like which parent is having a party, who's sitting where. I mean, these are things that a good parent coordinator is going to say, this is coming up. How do we make sure this is as little stress for the kids as possible, which ultimately has to be our main incentive here.
And what I heard Ben say, I think, was that early on when he's first starting on a case, there might be a lot of, over the weekend trying to resolve conflicts, but that's just like as they're getting to know you, maybe as you start getting a feel for the family, maybe that's when you can start looking upstream because they finally, kind of gained the trust of the parents. I don't know if I'm overreaching with what you said, but that's kind of how I interpreted it.
Well, and even if I don't have the trust of the parents, we can still make decisions together and we can still document those decisions. So obviously you can be more productive with parental buy-in, but even without that, we can still make some progress. I would add the caveat that parent coordination obviously isn't always successful.
I want to come back to that in a minute because I wanted to ask you, in your experience, do you see the parenting coordinator being used by the parents a lot when they are having difficulty interpreting the court's order, like it's not clear what it means, or is it just that they're like not happy with how it's actually working out and they're trying to like make some changes that everybody can live with?
I would say both. I see both. And I would add another category of people who want another place to air their grievances, to tell their story, to try and convince someone that they are correct, that they want to retry their case.
I would bend to that end. Do you think that when you first start with two parents, do you set a session so that they can kind of get that out? So, I mean, basically, instead of letting it reoccur continually, which it will anyway, but I mean, I would think it's important to set the session with the parent. And do you meet with them individually or together at the initial, at the outset, or both? But just to let them sort of, like you said, they're coming in there wanting to show you their hand and their grievances, just get it out of the way. What's your best way to deal with that?
Different PCs handle this differently. The way that I do it currently is I have an individual session with each parent first, and that allows them to tell their story and hopefully to feel heard without constant interruption from the other parent. After that, I set up a joint session where I really lay everything out, come up with a plan, procedures, things like that, and lay out the structure for how things are going to go.
So what kind of cases do either of you see as being conducive? Like when should an attorney try to encourage their clients to consider a parenting coordinator? What type of family law case is, best suited? I mean,
think,
obviously, if the parents have to agree on this, but I mean, I would think that they don't agree on a lot of things, and that's maybe why they need it. Tell me if I'm wrong.
I think it's sort of a medium conflict case myself. I mean, if you've got a domestic violence case or a case where there's I don't know, Ben can correct me, but if there's severe personality disorders where you're not likely to get any, I mean, the parent coordinator is there to make a decision and make a, like sort of say, this is what's going to happen, even if they don't have an agreement. I mean, obviously the goal is you have this session, you have an agreement about how things are going to go, be it extracurriculars or vacation time or activities. But I think you have to have some level of not cooperation, that might not be the right word, but competence, parenting competence, that doesn't involve the extreme cases where it's just not going to be possible because of domestic violence issues or things like that. Ben, what do you find?
I think in some domestic violence cases, a parent coordinator can prove to be helpful as an extra layer of protection between, and I say this in cases where I think there would be court findings of abuse, where the parent coordinator knows that, where there have been findings, facts on that. And in those cases, I think that the PC can serve as a layer of protection, and communication, for instance, can go through the PC. One of the goals of a PC is usually to minimize and streamline communication between parents. And with minimized and streamlined communication, I think a PC could serve as a buffer between those individuals until the victim has rehabilitated enough.
I mean, to be fair, these cases are obviously self-selected for people who have enough funds to do this. I mean, this is not for everybody. Sadly, there's a lot of cases that could benefit from parent coordination that fall at the end of the scale where it's just not a possibility, and that's unfortunate. I don't think there's any funding for pro bono parent coordination, but that could certainly be helpful for cases where there's a level of domestic violence that could benefit, like you said, Ben, from the extra layer of protection, but it's just not a possibility.
Yeah, there's 3 different provisions in this statute that reference domestic violence or coercive relationships. That and if you have the statute in front of you, and I'll make sure to circulate this afterwards, sections 7, 8, and 14 all reference the domestic violence situation and requires domestic violence screening. I was going to say something else and I forgot what it was.
Well, I'll just throw in there that the thing I like about the statute as an attorney, and I'm sure this is true for any professional, is that you can get out of this if you're not being paid by essentially sending notice to the parties. As serving as a GAL, I know that if I want to get out of the case and I'm not being paid, I've got to file a motion, go to court on it. But with parent coordination, yes, you have to send notice, which we talked about in our planning session for this, is not specify what that notice is as far as how long it is and to whom or anything like that. But the idea is that you don't have to go to court to get out of a parent coordination assignment if you're not being paid.
Yeah, I remembered what I was going to say because you mentioned that not everybody can afford a parenting coordinator. I guess it'd be nice to know, like, if there's a range of what parenting coordinators charge. But I think the bottom line is that it has to be cheaper than litigation, right? If you feel like you have to go to court every time you have a fight over who's going to attend which extracurricular event, or whether a parent can attend, or whether there's a parent is allegedly causing a disruption at an event, or all the different things that come up in all of these cases that we see all the time, I have to believe it's going to be in the long run cheaper to work with a parenting coordinator to try to resolve these issues than it would be to have your trial attorney go to court.
Parent coordination is not cheap, admittedly, and it does require a substantial retainer up front. With that said, it is cheaper than litigation.
Ben, do you feel like sometimes you're coaching parents to not need you? In other words, the idea up front is that, look, we're in high conflict because the divorce just happened, or because maybe a new girlfriend or boyfriend came online, or something happened to make it so that parents couldn't get along at all. Maybe they never could. But when they look at the bill and then when they think about the kinds of decisions that are being made, like, oh, okay, so you're going to this, and I'm going to that, or kid's going to this doctor or that doctor. Do they at some point, maybe, do you feel like you can let them leave the nest? I mean, has that been an outcome where, like, you served your time and felt like, okay, they can fly on their own now?
Yes, and I'll give the example of just the PC process itself. You might start out with very regular and frequent sessions. The goal isn't to continue that way. It's to start spreading those out as much as possible. There are some families where I might meet quarterly or only as needed, which might be 6 months, or I have families that are still technically out there, but I haven't heard anything in some time.
Do you think the motivation is that they got the bill and don't want to pay it anymore, or that they've actually learned how to co-parent, or both?
I don't know that they've learned to co-parent. In some cases, they've learned to parallel parent. Families tend to reorganize within a year or two post-divorce. So in that year or two where conflict tends to be higher, emotions tend to be higher, you're more likely to be needed. Right. But as things settle down and people move on, they remarry, they have new families, many people tire of the conflict.
Right.
And so I think that plays a big part as well.
That was my experience as a family law attorney generally, is that some people were surprised, but there's just like an attrition rate where there's some real energy for the conflict that dissipates over time. But what I wanted to ask, coming from that friend of the court perspective, is working with the people who are assigned to work on the case from the court side that are happy you're involved because you're helping them avoid the phone calls on every Monday morning about what did or didn't happen over the weekend or all that stuff. Yet there still needs to be a level of at least a line of communication between you and the people in front of the court to kind of say, like, when I told my fellow referees that I used to work with at Oakland County front of the court, that was me on this panel, I asked them, what were their concerns? Like, how do they feel about parent coordination? And they, their points were that, obviously there needs to be an order that's specified, that they realize that they're not out of the loop, a little bit out of the loop, but your role is to keep it away from the court. A referee's role is to keep it away from the judge. That being said, there needs to be some level of communication that makes it clear to all the parties what their sort of roles are at the time. How much you find yourself communicating with the front of the court staff to say, look, I'm on this topic or not, or I mean, do you have to, how much are you coordinating or talking with front of the court staff and the cases you've worked on?
I would say minimally. On a lot of cases, not at all. Some cases I may periodically touch base with the caseworker, but I historically have not had a lot of contact, at least in that role.
Can you be called as a witness down the road if there is litigation?
I could be called as a witness, yes.
Have you been as a PC?
Yes, I have. I've been called as a witness, and I've also been deposed.
Okay. So we have a question from the audience, and it actually ties into a series of questions I wanted to jump into. So I'll ask several questions right now, all about the child. So I would like to hear about, whether you're able as a PC to talk to the child, what those conversations look like, and so on.
As a PC, you do have access to the child, and I've never had parents object to me speaking with the child on either side. I generally try to leave kids out of this. I don't involve them unless I reach a sticking point. And then I speak with the child just about the particular issue. For instance, an extracurricular activity. Do you want to do fencing like dad wants you to do, or do you want to do tennis like mom wants you to do? And conversations are pretty limited to the issue at hand. Again, I don't have any control over the established custodial environment. I'm not interviewing the child looking to make custody and parenting time recommendations. I'm interviewing the child to help make some of these day-to-day decisions.
And so, children can come to you, or maybe you can find out from a parent that the child actually wants to talk to you. Do you ever have them tell you, hey, I don't like this parenting time schedule, or I don't like that I have different roles in each home, or like, have you ever had a child, or I guess they could, have you had that experience where a child's like sharing their feelings about the situation?
Yes, that's and I would say that goes along with the parent or parents using PC as a way to relitigate their case or some of the issues in the case. Kids see this as another chance, or I should say some kids in some cases see this as another chance to stand on their soapbox and tell someone what it is that they want. And often that aligns with, what one parent wants for them.
I mean, I think you're able to, unlike a judge, able to get into asking questions that kind of get to the why. Like instead of saying, do you want to do tennis like mom wants you to do, or do you want to do lacrosse like dad wants you to do? You ask them what they want to do and then kind of dig into like finding out what's driving their decision. It might be just because they want to make one parent happy, or, you know, they're afraid of one parent. I mean, it seems like as a PC, you're able to kind of get into what's going on with the child. And you're a limited licensed psychologist as well, right? So you have like this special ability, like to understand, you kind of engage them in a conversation that to draw out what's really going on.
And if the child's not in therapy, do you say, oh, this, I mean, you listen, hear the child out and say, either that's something to tell your therapist about and talk to, or tell the parents, maybe this child needs a therapist. Have you been in that situation?
Sure. Yes, because I certainly can't serve as the child's therapist. And if I think that's indicated, I would address that with the parents. And I think that's something that the order allows for too, is some of those medical healthcare related decisions you can make recommendations on.
And you're a mandatory reporter. The statute says that a parent coordinator is a mandatory reporter if there's abuse suspected, correct? Have you made reports about that? Have you ever had to make a referral?
I have made plenty of referrals, but I don't believe I've made any as a PC. It's not uncommon to have the parents or somebody making them while I'm serving as a PC. So contact with CPS is not uncommon. But in this role, I don't believe I've ever made a CPS complaint. Although as a limited licensed psychologist, I'm a mandatory reporter and a PC, regardless of their background, is also a mandatory reporter.
So this raises a tangential question. Is a GAL or a lawyer guardian ad litem a mandatory reporter? Tracy, do you know offhand?
I don't think so.
So that's interesting, because I think an attorney could be a PC potentially, right?
Yes.
Yeah, an attorney can definitely be a PC.
So it's just a different role, like, because now you're a mandatory reporter, which maybe is different role than.
And I was, as a friend of the court referee, I wouldn't be a lawyer generally, but under the statute as a PC, you are.
And referees are mandatory. Referees are mandatory. Interesting.
Yeah. Yeah, I've had to make a referral once at least.
So is there information that has to be disclosed or cannot be disclosed out of the PC relationship?
As a PC, the PC process doesn't have the same level of confidentiality that, say, psychotherapy does. This is not covered by the same HIPAA regulations. That being said, without that layer of confidentiality, you can choose to conceal things that the child has revealed to the PC, if the PC feels that may be harmful to the child.
I found that the language in the statute, you don't have to disclose it if the disclosure will compromise the safety of a party or the child. Exactly right.
Right.
So, and that is different than the rest of PC, which isn't a confidential process.
So there's a lot of requirements in the statute about what the parties need to decide before using a parenting coordinator. And we talked about some of them already, like the types of issues that we're going to allow the parenting coordinator to weigh in on. But one of the things I wanted to spend a little bit of time on is this subsection G. One of the things that has to be agreed on in advance is the dispute resolution process that will be used by the parenting coordinator, explaining how the PC will make recommendations on issues and the effect to be given to those recommendations. And so there's a little bit more to that provision. I wanted to talk a bit about it because I think as attorneys, we're very familiar with the process of, you know, the FIG-C process. There's a way of objecting to like what the FIG-C recommends or what the referee recommends, and you eventually get to a de novo hearing. What happens when you as a PC make a recommendation? Are the parties bound by it? Can it be modified by the court, and so on?
So I make what I term as recommendations, and those are binding recommendations until the court changes them. I make it very clear to people that I'm not the final word on anything. I make recommendations, and the parties are free to object to those. And I remind parties about that periodically.
Do you do it by in a letter or an email? I mean, how formal does the recommendation look? And do you,
Yeah.
Okay, my recommendations, I keep a running document of our sessions, but if I need to make formal recommendations, I prepare a letter and I provide that letter to the parties and their attorneys.
you know, when do you always provide it to the attorneys, or just when you're making a recommendation over, like if you have the parties agree to something, do you memorialize that in a writing and just say, hey, here's what everybody agreed to? And if they don't agree to it, do you handle it a different way, more formally, and then include the attorneys? Or do you include the attorneys whether there's an agreement or only if there's a recommendation to be made over somebody's disagreement? Do you know what I'm saying?
So if I'm sending out a letter, it's going to the parties and their attorneys if they have them. If the parties are in agreement, you know, I'm documenting that in my notes. And typically just a verbal agreement is adequate. If there's a question about it, I have it in my notes. I don't typically formalize anything unless it's a recommendation. If the party needs something formalized, if they need a written document to follow, I can certainly prepare that, but typically that hasn't been needed.
I'm looking at the statute. I don't see anything about it being in writing, but I would think that there are a lot of parents out there that are going to have a hard time remembering what the terms of the decision, you know, what the recommendation is without having something in writing. And I was just wondering with this whole process, again, looking at the statute, the PC process must ensure that both parties have an opportunity to be heard and an opportunity to respond to allegations before a recommendation is made. So I'm guessing like it's much more, it could be much more informal. You're not expecting them to submit, maybe one parent's submitting letters, but I could see a parent calling up and say, hey, I have a problem with this. But before you make a recommendation about what you're going to do, you're going to make sure the other party, what do you just call up the other parent? Or, hey, do you say, hey, we had this issue, send an email, we have this issue that's going on. This is what's being alleged. What do you think?
I think it depends a little bit on the situation, but I would like to have something documented in an email. That's not always practical. So, you know, there are times that it would be a phone call or a Zoom meeting. Often that stuff comes up in joint meetings, and when I have both parties on Zoom, that's an opportunity to respond. And I can make recommendations right off of that. Often parties have something additional they want me to review, or someone they want me to speak with before making a recommendation, and I can certainly do that. Parties, need to sign releases for any mental health providers who are involved. So it's easy to connect with people like that on a quick basis.
I mean, I have to think there's a real, I mean, just like parenting, as any of us who are parents know that some things can be well planned out and some things are absolutely spur of the moment. So if you're talking about a decision that, oh my gosh, there was a drill at school and kids are going home because because there's a whatever, who's going to pick the child up? Mom's busy, dad's busy. Is it okay if dad's girlfriend picks a kid up? Okay, we're going to arrange it quickly. And yes, that's going to happen. Might not be reduced to writing by you. It's just like a flurry of phone calls resulting in a decision that's not really needing to be formalized versus, okay, let's look at summer vacation. Mom's going here, dad's going here. Here's the dates. Here's the whatever. Let's formalize that. I mean, they're just like parenting generally, as I said, I would think there's a wide range of outcomes with regard to how parent coordinators solve those issues for parents.
And I would tag on to that it is not always possible to solve your client's issues in the moment. Some of that stuff happens too fast. You have, well, for you guys, it would be a day of trial. For me, a day of clients, or a day of report writing where I'm not looking at my email, but when I do, I go, oh no, and see a flurry of emails from people, and then you deal with the fallout of that and try to get people back on track.
Right.
And on the front end, it gives you a good example of how people react. And sometimes that can be very helpful in terms of understanding your clients.
Well, one of the things that when I talked to the referees and we talked about how helpful parenting coordination can be, one thing they expressed to me is that it's not helpful when a parent coordinator aligns with one parent or the other. And I have to think that just with personalities the way they are and the types of cases that might even rise to the level of needing parent coordination, you have the kind of personalities where it might be very difficult to work with both parents, and there might be an appearance of alignment with one parent over the other. How do you avoid, if you don't mind my asking, how do you avoid that sort of appearance of bias if you have a strong personality
Alignment, yeah.
disorder that makes it hard to not, if it's obvious you're going to align with the parent who is reasonable and not the other parent, but to make sure that there's a buy-in from the parents in the court, what do you do to protect yourself from that?
Well, first, I think it's okay to have a bias, and that bias needs to be for the data.
And the kid.
So that's where you want to align yourself. You can protect yourself by spending roughly the same amount of time with each parent, by alternating sessions so that one parent goes first and then you're dealing with the primacy bias, but the other parent goes second, and you can kind of counteract the primacy bias with the recency bias. So there are ways to help manage that. It's also helpful to keep in mind multiple hypotheses for what's going on, for how the children are responding. We don't want to jump to abuse concerns. We don't want to jump to alienation concerns. We want to follow the data. Reviewing collateral sources, whether those are documents or speaking with other professionals on the case, especially people who can help challenge some of your notions.
If there are any,
Sorry.
oh, go ahead.
Do you find yourself talking to, I don't know, teachers, coaches, grandparents, people like that very often? I mean, do you talk to collateral sources a lot?
That's not uncommon. Therapists, principals, probably the most common, other medical professionals also.
I mean, and the statute lists a lot of different types of information that the parenting coordinator agreement should address what the PC has access to, including all this information we're talking about now. So it's you're basically getting their buy-in at the beginning, right? That you can talk to the teachers and the therapist and so on.
Right, and by signing the order, yes, they are agreeing with that. Going back to the order briefly, I find it helpful to include verbatim the statutory language right in the order, and you can review that with clients, and that makes it really simple in terms of what the parent coordinator's role is. And always look back at that and say, this is, what I can and can't do.
If we have any PCs in the audience, I mean, feel free to pipe up and let us know you're there. I anticipate that most people here are attorneys who would potentially use a parenting coordinator if, once they learn more about it. I had a question. I think this maybe is more for Traci, but did you ever sit on a case where, so we're talking about when a PC makes a recommendation and it becomes, the order of it becomes what binds the parties until further order of the court, right? So there's a process, there must be a process, it doesn't say about an objection, but there must be a process at least to file a motion to modify the PC recommendation, right? Because that's like basically how the statute written. Do you remember, I don't know if we get to referee or not, but do you remember ever sitting on a case where you were basically evaluating the PC recommendation and making a decision about whether it should be modified or not?
Yeah, I mean, I would say not about modification of the order appointing the PC, but I'd have to say that most often there's a strong bias, and I don't want to, I don't work for the court anymore, so I don't have to say, I don't have to modify this. I think with regard to the referees and the judges, if you see somebody coming in that's fighting the recommendation, the parent coordinator has been working on the case, there's a strong bias against the person fighting it. I mean, it's like, come on, we appointed a neutral, they've worked with you.
Right.
You're coming in here saying this is unfair. And not only is it sort of the court saying, why are you bringing this back to me? But why are you the one fighting what's obviously a reasonable recommendation? I guess the assumption would be that the parent coordinator did something reasonable, that the decision they made, that the recommendation they made, it made sense. And the person fighting it is like, why? I mean, in Oakland County, like I said, when we do motion call and things, we have the friend of the court, the parent, the counselor, the family counselor, talk to them and make a recommendation. So anybody that goes before the judge or referee say, okay, so here's the recommendation. Why don't you like it? So it's like, why don't you like it, to the parent who didn't like it? So the parent coordinator has actually worked with the parties for a while. There's probably even a stronger assumption that the person fighting it's not reasonable.
Fair enough. And then if there are any of the attorneys in the audience who have done a motion to modify or, do something about a PC recommendation, please pipe up because we'd love to hear from you. I don't want to switch gears if we're not ready yet, but I had some more questions about the financial aspect of it. But if I don't want to go there unless if we had more to talk about with regard to the role of the PC and how we've talked about how the PC can help a case and what is the PC really doing in the case. It seems like there's a lot of cases where it could be helpful to have a PC. Ben, you had mentioned the other day that most of your cases are high conflict cases, and I'm like right there with you. Like the cases that come to appeal are the highest of the conflict cases. And then Traci described it as a medium conflict case. So I'm just, from your perspective, Ben, are your cases that are ending up with a PC, are they medium conflict, or is it possible to get them to agree even in a high conflict case? Agree to using the PC?
It is, with the right attorneys, it is possible to get people in high conflict to agree to PC. And I was, when I made that comment, I was referring also to my custody work and
Right.
and psych practice in general. But that definitely applies to PC. By the time a case gets to my office, it's pretty unpleasant.
Now, we do have a question from the audience. I think this is more for Ben. How do you avoid telling the parents to just grow up? Maybe you don't. I don't know. Maybe you don't avoid it. Tell us how you handle, like, parents are being unreasonable.
It depends on the personality of the parent and my relationship with them. There are parents where I have said things like that too. There are other parents who I don't want to make things worse. And if I were to say just grow up, I'd be making things worse.
Have you invented words that say just grow up without saying just grow up?
I have danced around that, certainly.
What's your best advice on that? I have a GAL case where I wanted.
I'm dancing around it right now.
Come on, what are the words you can say that really convey, come on, guys, just grow up? What's a PC way to put that?
Again, it's very dependent on the personality style of the parent and my relationship with them. There are parents I'm very formal with, and there are parents I'm laid back and we swear, and I try to meet clients where they're at and behave in a way that's most likely to get a mediated agreement. As you know, that mediated agreement is ideal. I'm not looking to make recommendations. I don't know.
Got it.
I don't know everything about this case. I don't know what these parents know about their child. I don't want to be making decisions for this child in lieu of these parents. I mean, I'm just some guy who has this training and experience to try and minimize conflict for people. But if they can do it themselves, I want to facilitate that.
I mean, that's exactly right. I mean, don't you start to say, look, I'm happy to help, but in an ideal world, you don't need my help. And I'm hopeful that this is something we do for a short period of time. And together we can develop the tools so that you don't need somebody like me in your children's lives, in your lives at all. Isn't that the ultimate outcome, that you can help them through a period of time and give them the tools so they don't need you at all?
Yeah, and that, at least in the early stages of divorce, involves helping them disengage. You know, looking at emails and text messages and saying, don't respond to this. This just, you're going to go down a rabbit hole, and now we have another conflict and fire to put out. I talked to the other parent about sending the message in the first place, but
but they're often not dealing with the issue at hand about who's going to soccer practice. They're really dealing with the things that they didn't resolve in their divorce. And to the extent that they're relitigating those issues, it's not helpful going forward, and helping them let go of those issues as quickly as possible. But we all know everybody has their own timeline, and some people never forget those issues. Some people take a year, year and a half, some people take 6 months. Some people take a little longer to stop giving their emails, include all the slights from the divorce, all the things that hurt them, and trying to throw arrows to the other party that then the other party wants to respond to, I think is what you're saying, and keeping them focused on, okay, who's having the graduation party, not all those other things about, whatever, who took what property from the house or things like that. I mean,
Sure. And I have no, I mean, I suppose I could mediate some of those minor property issues, but I certainly couldn't mediate anything major. I'm not an attorney. I don't have the expertise to do that. And I have no authority over anything like that.
Ben, are you ever given the heads up that one of the parents or both of the parents have some sort of mental health disorder? Like, so you know what you're dealing with without, like, you get a file on them so you can kind of read it and know what you're dealing with? Or is
that's another common referral reason for PC, at least to mental health professionals, would be mental health problems with the parents. And again, by the time a case gets to my office, it's typically pretty bad. I started a recent case where I was, provided several thousand pages of documents to review, including the case file, social media history, psych evals, police reports, CPS reports. At the front end, this tends to be costly to get me up to speed and to get on board to the point where I know enough to make a reasonable recommendation. Sometimes that can be costly and time consuming.
Do you have upfront input from attorneys from either party? And in fact, like you said, in order to maintain an appearance of being non-biased, which you should be, obviously, you spend equal amount of time, whether they're the primary, whether they start with you or the most recent. I use some terms I think were interesting from a psychological perspective. But if you have one party where there's an attorney who's actively involved with calling you, giving you information, sending you reports, letting you know all the stuff that happened, one that's taking up your time and is good advocacy maybe, but you're not necessarily looking for the other attorney to then give input. So in other words, even though you're having equal time with the clients, if one attorney is more active in trying to tell you what a terrible person the other parent is that, I mean, how does that work? I mean, because that, I would think that would be like, there's mostly attorneys in this audience, obviously. And if they're representing somebody who has a parent coordinator in their case, they may find it helpful to continue to contact you and let you know things they want you to know from the case without the you know what I'm saying? Like that would.
Sure. And in my experience and with the cases I've taken, the attorneys are very respectful. They're not contacting me like that. They're responsive to me if I need information. They're always helpful. They're not over involved. I typically have a joint meeting with the attorneys on the front end before I accept the case. But again, that's a joint meeting, and I'm discussing the case with them together. And I ask them for documentation up front because they have a better idea typically of what would be helpful than the clients do. So that helps streamline that process a bit. As PC, you can have ex parte communication with people. And I've certainly done that. But I generally try to avoid that. And with attorneys, joint meetings tend to work best in my experience.
Well, this has been really helpful. I think a lot of people, like, even though I've known about the statute since 2015, it's just not something that I think a lot of attorneys encounter very often. So I'm hoping a lot of people are getting ideas for their cases that a parenting coordinator might be appropriate. So Ben and Traci, I really want to thank you for your time today. It's been extraordinary. And hopefully you'll both be doing more PC work in the future and avoiding litigation.
That's the goal.
Don't we? I think we want to get these cases back up to the Court of Appeals work, Lisa, no?
It's okay. I'm trying to fix a few things. I can do other kinds of appeals.
You don't really need to work on these. These parents don't need it. It's not best for these parents to have to.
Right.
go.
No, that's, I mean, the thing is, and next month, our webinar, and I always forget to announce the next month's webinar, but we're talking about a lot of issues where the courts aren't following the law. And a lot of what I've been working on is trying to get courts to follow the law. And guess what? That means if they do, I'm not going to have as many appeals, but that's like that's not why I'm here. I'm not here just to do appeals. I want to help families. And so if we can help more families by having fewer appeals, well, then I'll just do other appeals. I mean, there'll be other things to do.
Like you said, I hadn't looked at the parent coordinator statute carefully until we were on board for doing this webinar. And looking at it, there's so much discretion that they're given. They really are given a wide range of things that they can work on. That really does help families if used properly. This is really avoiding the higher conflict that goes with, court appearances and Court of Appeals and things like that.
And it's a pretty well-written statute. I think there's that one provision about the recommendation being the order of the court. Like, it's a little confusing about how that actually works, but for the most part, it's a really well statute. And obviously I wasn't involved at all, but I just remember when it came out. And we probably had a family law section committee that helped work on it. And I don't remember who was involved with that. I don't know. It could have been you, Traci.
I was chair 2012, 2013, or 2011, 2012. So this came after me. So I'm sure I was in my checked out emeritus status.
Right. I hear you. So anyway, again, thank you. I'm going to stop the recording and we can say our goodbyes.